We miss you, Mr. Baez.
I wish I could say the same. I do have one issue that I'd like to bring up.
Yes, sir.
I apologize, but I continue to see Mr. Ashton's facial expressions as I'm doing my closing arguments, and I would ask that he refrain from showing gestures or something, whether he approves or disapproves of what I'm saying. I think the court's been clear about its order, and I would just ask that that stop.
With the signages, I can't see Mr. Ashton, but as I've made it quite plain and clear, we don't need any facial expressions of approving, disapproving, or anything else. Anything else?
I'm ready to go.
And one person only. And he could get up here and lie all he wants and dance around the truth, but the truth is the truth. And depending on who's asking the questions, whether it's this laughing guy right here or whether it's myself.
Objection. Sustain. Approach the bench. I took an opportunity to go and view the video of the segment that Mr. Baez was talking and Mr. Ashton's reaction and Mr. Baez's corresponding response. Needless that response on behalf of Mr. Ashton and Mr. Baez violates this court's order. I have constantly told both sides from the outset when I first took over this case, I personally gave each one of you the 9th Judicial Circuit courtroom decorum policy, which is enacted by administrative order and has been in place. If I can remember, I signed this order in February of 2003. I gave everybody a copy. More specifically, item 12. Counsel shall admonish all persons at counsel tables that gestures, facial expressions, audible comments, or the like as manifestations of approval or disapproval during the testimony of any witness or at any other time are absolutely prohibited. There has been this accusation throughout the trial that it has been going on back and forth. I have told you on numerous occasions I spend very little time watching the attorneys. I assume that you are all professionals, that I don't have to watch. You're all charged with the responsibility of following the law. So maybe I am misinformed when I think you will follow the law. But I'm beginning to see that orders or anything else may not mean a hill of a bean to any of you. So go look at it, and I'm going to do what I need to do. As both sides had an opportunity to view the video clip.
Yes, Your Honor. Sir.
Anything the state would like to say, followed by the defense.
Your Honor, as I viewed the video, I appear to be smiling behind my hand. That is what I saw in the video. I wasn't laughing. I wasn't nodding. I was doing what I could to make sure that my expression was not seen by the jury. If I exceeded this court's order, I apologize. But I was doing my best to make sure that nothing I said or did was seen by the jury. That's my observation of the tape.
Defense?
I have have no other comments other than I would not request that Mr. Ashton be held in contempt because of his facial expressions. I think this case has been highly emotional for both sides, and all I really request is that it stop because of the serious nature of what's going on. I also apologize for getting caught up in the moment as well and making those arguments, but I think after 3 years of working with Mr. Ashton, I do not wish that upon him in any way whatsoever, and I as well have my apologies to the court.
Anything anybody else wants to say?
No, sir.
Okay. I will accept that for now, but as I told both sides, if it happens again, the remedy will be exclusion of that attorney from further participation in these proceedings. As I told you at the bench, there are at least 3 attorneys on the state side. I don't know whether Mr. George was going to participate in closing arguments, but it'll be either Ms. Burdick or Mr. George. And it'll be Mr. Mason, Ms. Sims, Ms. Medina, or whoever else y'all have over there, along with some other things that will be quite unpleasant. Enough is enough.